Hi, I'm Tim Naftali. I'm director of the Richard Nixon Presidential Library and Museum in Yorba Linda, California. It's December 1st, 2008, and I have the honor and privilege to be interviewing Judge Robert Bork for the Richard Nixon Oral History Program. Judge Bork, thank you for doing this.
Glad to.
Let's start with some biographical details. You are at Yale Law School. You're a professor at Yale Law School when Richard Nixon is elected.
Correct.
Tell us about your first interactions, if any, with President Nixon or members of his administration.
Well, the first interaction was actually not personal. I wrote an article in the Republic in 1968 in favor of Richard Nixon. And as a result, I went on to London on a sabbatical, and the postman would bring these invitations to inaugural events because I wrote the article. They weren't very large inaugural events. But I remember his eyes bugging out because he thought he was dealing with some international celebrity. He wasn't. Heard no more from it until I went back to Yale. And then one day I got a call from Richard Kleindienst asking me, in effect, if I were offered the post of Solicitor General, would I accept? I said I certainly would. And he went away, and that evening I got a call from John Dean, who asked me to come down to Camp David to discuss it with Nixon. And Dean said with a hollow laugh, "I trust there are no skeletons in your closet," which I thought was kind of an interesting question from him. And the following morning I did fly down to Camp David and spent about, I guess, 45 minutes or maybe an hour with Nixon. It was a very interesting conversation because he discussed his philosophy in general, and he kept stressing that he wasn't really as conservative as I might think. I think the trouble was he couldn't believe that I was as conservative as he would hope, or even more so than he was, because he couldn't get used to a conservative professor. They just didn't exist in his world. He also gave me a very considerable lecture on the role of a judge and how judges should behave. Now, I thought it was very good. I thought I could have given a slightly better lecture on that, but then I had been teaching that for 15 years, and he was running all kinds of things and still had a firm grasp on judicial philosophy. And we talked about such matters for a while. And he said, "How old are you?" And I said, 46. And he said, "Perfect." I didn't know why he said perfect. I was very slow in the uptake about these matters. Then, as I left, he said, "It's just too bad you went to Yale." And I said, "I didn't go to Yale. I went to the University of Chicago." He said, "That's almost as bad." And we discussed why the glass main building in Chicago hadn't been shattered by rock-throwing students. Nixon had participated in the dedication of the building. All in all, it was a highly informative and enjoyable discussion. And I must say that I'm sure other people report accurately different things, but I never saw Nixon when he wasn't very good. I never saw him equivocating or lying or doing any of the kinds of things for which he is renowned, fairly or not. So my picture of him is not rounded. And if there is another side to him, I didn't see it.
This meeting to discuss becoming Solicitor General, if it involved Kleindienst, it must have happened before April of '73.
Oh yeah.
When was this?
Well, I think it was probably the end of '72.
Because Griswold hadn't left yet.
No.
But I guess they knew he was going to leave?
They were going to make sure of it.
Can you tell us a little bit about your predecessor, Griswold, since we mentioned his name?
I do not think he was a great lawyer. His argument in the Supreme Court, he argued, he always had a loose leaf notebook which he read from. Just kept turning pages. And he would not answer questions. So after a while, they gave up asking him questions. He was an odd man. I think he's a much odder man than Richard Nixon, in a way.
Before you were offered, when you met with the president, I guess he didn't offer you a job, did he, at the end of this conversation?
Oh, sure.
He did offer you, said?
Pardon me?
He did offer you?
Yes.
But he said you'd have to wait for a while, because, of course, Griswold doesn't leave until the middle of the
night. I was free to ask Griswold to leave. In fact, Kleindienst told me, well, why don't you tell him to leave? But I still had the impression that Griswold was a grand old man of the law, and he asked me as a personal favor if he could stay on till the end of the term, which is in June. So I said yes, it didn't matter to me. He stayed on, although from time to time Kleindienst would ask me why I didn't ask him to go. But it was clear that he was going long before I was offered the job.
So this just so we can try to set this in time. This is after the '72 election.
Yes. I suppose the '72 election was so clear cut that he could have offered me at any time, but he waited until after he was elected.
Let's go back in time earlier when you did some work on the busing issue. When did you start to do work as a consultant for the White House?
Well, I didn't do work as a consultant except on that one issue. And that's one reason I'd like to see the log books or whatever they keep, because I'm not entirely clear what the time was. It had to be around July or August of '72. And we worked in the new executive office building, Charles Allen Wright and I. And there was another group of lawyers there, my old partners from Kirkland and Ellis, a firm I was with for years. But we didn't know they were there. They were working separately, and they knew we were there, but we didn't know about them. So we worked there for a week. And Charles Allen Wright is a very fast worker. He drafted a bill. Well, we both participated, but he was the main drafter, and I didn't like the bill. So at the end of the week, we went to meet with the president and the cabinet committee on education in the cabinet room in the White House. And that was an interesting, an odd, very amusing episode, because we went in. I'd never been in the cabinet room. I didn't know where the president sat. And rather foolishly, I thought he'd sit at the end of the table, which is actually a bad place to sit. So I walked around the table all the way and sat down almost in the middle. And presently the president came in and began meeting people and shaking hands and coming around the table. Met the people from Kirkland and Ellis, the various cabinet people, the various staff people who worked on this thing. And I was the last one he came to. And he hadn't seen me, hadn't noticed me. And he looked up and somebody, I guess George Schultz, said, "And this is Professor Bork from Yale." He heard Yale, he saw the reddish beard, and recoiled about a foot. Somebody has blundered. How'd this get in here? We went on with the meeting. And during the meeting, I think it was Schultz, called on me if I had any comments about the bill. And I said there was no federal power to do what they were trying to do the way they were doing it, unless you relied upon a case called Katzenbach against Morgan, which was a case that the Supreme Court allowed Congress to change the meaning of the Equal Protection Clause of the Constitution. No, that's just can't be done. And furthermore, they decided, the Supreme Court said, you can change the meaning to require more equality. You may not change it to require less. So it was a pretty raw political decision. And I said, the only way you can uphold this thing is to rely upon Katzenbach against Morgan, and that is corrupt constitutional law, and this administration shouldn't endorse it. And Nixon said, I believe that, but I didn't know there was a professor in the country who did. I may have got the job right there, I'm not sure. But he was amazingly, he knew about constitutional decisions. How, I don't know. He must have studied everything, foreign affairs, domestic affairs law and everything, 18 hours a day or something. He was incredibly knowledgeable. But he then went off and redrafted the bill himself without Katzenbach against Morgan. The bill didn't go anywhere in Congress, of course, but it was probably designed as a vote-getter anyway. We wrapped up the meeting in the cabinet room and went off to the Oval Office. Those of us from the outside, where he had a very relaxed, pleasant conversation. And that was the last I saw him until I got the call from Kleindienst asking if I would take the job.
Do you remember to back up a bit, do you remember that press conference you were supposed to give? You were in Vermont at the time in March of '72 to talk about the moratorium?
Yeah, I don't recall the press conference since, as you mentioned, it didn't exist. But
yeah. But, well, actually, it was a press conference, but you and Charles Wright weren't there.
That's right.
Elliot Richardson did it instead of you. But how did you start working on the busing issue?
They called up Roger Crampton, who was a professor from Cornell and a fellow I knew, a friend of mine, was in the administration. He was Office of Legal Counsel. And ironically, he was being let go, but they had him call me to come down and work on the bill. And I think Ken Dam called too. Ken Dam was second, I think, to Schultz. In any event, they called me to come down to work on the bill, so I went down and worked on the bill.
This was the, was it a bill? There was a question as to whether Congress would pass. It wasn't even a question of amending the Constitution. Hadn't people even mentioned
what?
This was the issue of busing.
Yeah.
And whether there should be a moratorium on busing.
Well, yeah, I don't know about the moratorium idea. I based my support on the idea that, which had a lot of support in the law, and indeed had support from Archibald Cox, that you could cut back on a remedy so long as you didn't cut it back so far that the underlying right disappeared. And that would mean you could obviously regulate busing and trim it back. It was some of it was getting pretty wild in those days. They were ordering whole cities turned over. So that was my approach, which was an approach of yes, you can limit busing, but not entirely.
Well, can you draw a straight line from that to the Milliken versus Bradley that decision in July of '74. So you must have pled. You must have, as Solicitor General, you must have done the pleading in that.
No, I don't think so. It might have been, the briefs might have been filed under Griswold.
Oh. I don't know how long in advance a brief was filed. Well, you're right. It could have been.
Yeah, I don't recall working on that case.
So Griswold, you and he have been in touch. He retires in June of 1973, and you come to Washington. And what do you find on your plate when you arrive?
Well, of course, a stack of briefs for one thing, but in addition to that, through a complicated procedural tangle, Justice Douglas wound up ordering a stop to the bombing in Cambodia. Now, as you recall, as everybody recalls, the United States had an incursion into Cambodia because it was being used by Viet Cong and Vietnamese forces to attack into Vietnam. And I won't go into the merits of it. I think it was well justified because the government of Cambodia agreed to it. But in any event, a district court judge in New York City ordered the bombing to stop. The government appealed to the Second Circuit Court of Appeals, which issued a stay of the judge's order. Doesn't reverse it, just holds it in abeyance until it can be argued, but it doesn't go into effect. The other side then appealed to Justice Marshall. Now you're initially in a situation like that, you have to go to the justice who was assigned to your circuit, as they had no choice but to go to Marshall. And I argued the case in chambers with the lawyer from the other side, just the two of us plus Marshall. And Marshall was very impressive. He refused to lift the stay that the Second Circuit had put into effect, which meant that the bombing continued. I knew what would happen next, although my staff didn't seem to understand it, because I knew Douglas. Once Marshall refused to issue a stay, or lift the stay, they were free to go to any justice. And they chose Douglas, who was on the West Coast. The court was out of session. And they went flying out there, and I sent a team from the Department of Justice out. And they argued the case in the post office in some little town in Oregon. And they said, well, Douglas would never do a thing like that. Because I said, he will. And he did. He ordered the bombing to stop. And at that point, I didn't know what to do exactly, but I was then told, I wasn't familiar with, at that stage with all the ins and outs of Supreme Court procedure, that now that Marshall had refused to lift the stay, that did not mean he was not able to impose his own stay on the order, so that the bombing would not stop. So we petitioned Marshall for his own stay, and I got a affidavit. I could swear it was from Bill Rogers, who I think was Secretary of State at that point. And he must have been, because he wasn't Attorney General, pointing out that the administration had negotiated with Congress for a phased withdrawal and a phased end of the bombing. Because if the bombing suddenly ended, the villages which had been friendly to the United States and our own troops would be in desperate shape, in desperate peril. The bombing was all held the other side back. And we filed that in the first thing in the morning, and we sat there all day long without hearing from Marshall. We were getting kind of nervous when finally Marshall issued his own stay of the district court's order to stop bombing, signed by 7 other members of the court. That's everybody but Douglas signed on to that thing, although they weren't required to. They were making a show of unanimity. And but that was, my first reaction when they called up and said, "Can we continue bombing?" was, "Why don't you ask your lawyer?" And I said, "Wait a minute, I'm their lawyer." So that one went by all right, but for a while there it was a little hairy. And people in the administration, like Kissinger, were quite upset.
It's a little after, a few weeks afterwards, and we'll have to try to find that date for you, that Alexander Haig contacts you.
Yeah. I didn't know Haig. And I was sitting in my office at Solicitor General when he called and introduced himself, said, "What time did I go home?" And I told him. He said, "Well, since I went right by the White House, would I drop in and see him when I left?" I had no idea what was going on. So I did. I dropped in, and he sat me down and said, "The president wanted me to resign as Solicitor General and become his chief defense attorney." Well, that shocked me because I had no idea anything like that was coming, or they would ask it. And later on, I remember after a different episode over at the White House, Elliot Richardson said to me, "Why would he call you? You were a professor." I said, "Well, before I was a professor, I was a practitioner, and I put together big cases. I used to put together antitrust cases, which were quite complex." Richardson didn't know that, but I guess Nixon must have been in touch with my partners who were at the busing bill session. And Haig is very persuasive. He made the case. It sounded like only I could save the Republic. He discussed the fact that their legal operation, he said, was in a shambles. For example, they did not know in advance that Butterfield was going to disclose the existence of a taping system in the White House. I've heard that disputed, but anyway, in addition to that, there was no strategy. People were charging off in different directions. And he said, he said, "You'll be in charge." And I said, "How do we know? How people know I'm in charge? You give me a title?" He said, laughed, and said, "No." He said, "You'll be in charge because you'll be the only one with access to the president." And I said, "Yeah." And I said, "Until I give him the wrong advice, and then I sit by a phone that doesn't ring." And Haig says, "That's very perceptive of you." But that's the way it works, and I was not about to get myself into a position where I sat and stared at the wall for months on end. I said, I had just enough brains to ask for 24 hours to think it over. I went home, and I called a friend of mine, Alexander Bickel, who was in town. And he and I spent the night discussing it and drinking a little, I must say. And by morning, it was quite clear I didn't want that job. So I went over to see Elliot Richardson before going down to see Haig. And he made some good suggestions. I went down to see Haig, and I said a couple of things. One is I have to hear the tapes. And Haig said, "You may not hear the tapes. This president feels so strongly about the institution of the presidency that if he's ordered to give up those tapes, he will burn them first and then resign." And I started to say, out of curiosity, "Then why does he burn them now?" But I decided it was a wrong thing to say, because somebody might burn them and say, we're burning the tapes on the advice of the Solicitor General. So I shut up. Then I said, furthermore, I'm not a private attorney. I said, who's going to pay me? I said, Richard Nixon. He said, no, the government. I said, well, if the government pays me, I'm a government attorney. And I'm not free as a private attorney would be if he comes across bad evidence to sit on it. I'd have to turn it over to an impeachment committee or somebody. I sensed the interest in my services was waning at this point. I made a couple of other points. And then Haig said, finally said, I see your point. I guess it wouldn't work out. About 2 weeks later, Nixon called me on the phone. No particular reason, just chatting. And as my wife said, it was his way of saying it's all right. I don't hold it against you. But they got other attorneys, and nobody seemed to raise the question about whether they could hear the tapes and whether they knew what the story they were telling was true or not.
When you were chatting with your mentor and friend, Professor Bickle, did you decided that this would be a condition, listening to the tapes would be a condition to you taking the job? You'd already decided you didn't want the job, though.
I didn't want it, but if they satisfied all my conditions, I don't know how to turn it down.
I know it's a long time ago, but did you really think they'd let you listen to the tapes?
I don't know. I didn't think about it that way. I thought they might. I didn't realize at the time, what we now know, that those tapes were almost inaudible. I mean, I'd still be there trying to make out what's on those tapes. That was the genius of the Stennis compromise. Stennis would never been able to figure out what the hell he was listening to. But it seemed to me I had to hear the tapes. I couldn't go and begin telling a factual story. I had no idea whether or not there was anything to it. In fact, it might be contradicted by the tapes, for all I knew. But some other attorneys took the job and did just that. They went in and made up stories and told a story.
At some point, J. Fred Brizard was allowed to listen to the tapes, I believe, but perhaps not that early.
I don't know.
You mentioned Richardson's name. Tell us about the state of the Justice Department when you arrived in June of '73.
When I arrived, I think a lot of people at the Department of Justice were dissatisfied with the way things were going. Because, and I can't do any detail because I don't know exactly what their concerns were, but there was a feeling that it was kind of motionless. And at my swearing, when I was sworn in, it was in the Attorney General's conference room. I was sworn in by Warren Berger. And after the swearing in, of course, we gathered around for reception. And I heard somebody say, now the department's going to start moving again. But it didn't mean just me. He meant Elliott and Ruckelshaus and so forth. It looked like a whole new set of people who looked a little more vigorous than what they had before. Kleindienst was an interesting fellow because I wouldn't have suspected it, but on his wall, he had a Phi Beta Kappa certificate from his junior year at Harvard. Now, that's not the kind of accomplishment you associate readily with Richard Kleindienst's name. I think he was brighter than we thought. I think what it was he was rash. he would rush to say. When I first got there, I had the case with which somebody in the department had signed the wrong slips, and it looked like we were going to have to let about 400 criminals loose. And it looked like it had political overtones, but because somebody screwed up. I went down to see Kleindienst and said, "This is what we face. I have three options." I said, "One." I gave him the first one. He said, "Do that." I said, "Wait a minute." You didn't even hear the other two. He was like that. He would draw and shoot very rapidly.
The special prosecutor was the Watergate Special Prosecution Force had just been assembled when you arrived. Please explain to us what, if any, connection there was between the Office of the Solicitor General and the WSPF.
What there was, what?
What relationship, if any?
Oh, well, almost none. I'm trying to think of at one point, Elliot, the White House began to scream about investigations into matters that were not related to Watergate. And Elliot called me in and said he clearly had intended a special prosecution force to look into matters related to Watergate, not anything else in a man's background or life. And he said Archibald Cox agreed with that. I think he did. So Elliot asked me to sit down with the jurisdiction and rewrite the jurisdictional statement so that it was clear that it was aimed at Watergate and not at the world. But before I could get finished with that, the roof fell in, and there was no point in worrying about the exact terms of the charter at that point, for reasons I'll go into, if you wish. The only other, I was in a meeting with Elliot in which the White House had been complaining that Cox was getting into national security matters. And there was a discussion of how to deal with that. And there was a problem about, a suggestion about getting a retired counsel from the CIA or somebody to act as a sort of master and decide what things were national security and what weren't. That too was cut short by events. And the only other relationship I had with the Solicitor General's office had with them was the Saturday Night Massacre.
We'll get to that when we change tapes.
No, actually, we're rolling
Usually,
again.
okay. Yeah. Usually it's happening. Yeah. Let me ask you about the national security issue that came up. That had to do with the plumbers, didn't it?
I don't know.
Because one of the things Jaworski will do after he comes in is he will proceed with investigating the plumbers as part of his. He views it as part of his mandate.
Probably so. The truth is that I didn't have much to do with Cox, and I had nothing to do with Jaworski, because the last thing I needed was any allegation that I was interfering with Jaworski. So I told him when he came in that he was on his own, and I was not going to interfere with him. And he said in public that I had kept that promise.
Well, then before we go to the Saturday Night Massacre, let's talk about Agnew. Mm-hmm. When you meet with Haig, one of the things to discuss possibly becoming the government's lawyer, or the president's lawyer, doesn't he raise the Agnew?
Yes.
How does that come up?
It was an indication of the fact that things were coming apart, and that they were facing battles on many fronts, one of which was Agnew, and they needed a central direction, a central strategy. some lawyer could give them.
And that's the first you hear about.
Yeah. Now, Agnew had approached me at the inauguration, as a matter of fact, and later and said he wanted to meet with me. And it was kind of obvious he was considering a run for the presidency, and he was looking around for some what he regarded as talent to help him out. Well, when the day came and I went to see him, I didn't know that he was in trouble, but he knew it. So we had this utterly colorless conversation, which actually nothing of interest got said. And then he called the staff photographer, had a picture taken, gave me a picture, and ushered me out. That was my extent of my contact with Agnew until I was involved in trying to get rid of him.
Let's fix that real quick. I'm sorry.
Can start?
We can start.
Thanks. You once told the New Haven Register that we're both smiling, that you and Elliot Richardson were prepared to resign if President Nixon did not support indicting Agnew, and that you actually met with the president to discuss this issue.
Oh yeah, that was quite a...
Could you please tell us about that?
Oh sure, that was quite a moment.
Thank you.
It requires a little background. The U.S. Attorney in Baltimore was investigating corruption among contractors and their relationships to governmental units. They were not looking at Agnew. They had no reason to. But Agnew's name kept coming up as they investigated these guys. So finally, it got to the point where they convinced they had a case against Agnew. And the U.S. Attorney called Elliot Richardson and told him that the Vice President looked like he'd been taking bribes and was still taking bribes. He was not for anything he did in the White House, but still receiving increments of what he earned before by his corruption. So Elliot told the White House, and we then, at the Department of Justice, we got into a thing. There was some feeling, perhaps, that we shouldn't indict Agnew. And Agnew went to the Speaker of the House of Representatives and said that we were considering indicting him, and that would usurp the power of the House to impeach. And he couldn't be indicted before he was impeached and removed from office by conviction on impeachment in the Senate, which posed a political problem, as well as a legal problem. And I take some credit for having solved both, because I'm jumping ahead, when it got sticky with the House of Representatives, we sent back a letter saying, Elliot signed it, saying that we had to indict Agnew because if we tried these other people, if we tried anybody, Agnew's name was going to be all over the papers as a conspirator. So, you're not going to hide anything. And furthermore, if we delayed indicting the other people in order to arrange matters with Agnew, the statutes of limitation begin to run. And we couldn't let that happen. So we sent a letter like that to the Speaker, and we put that in our brief, as a matter of fact, I think. I'm not sure it's in the brief or not.
Well, the arguments are in the brief.
About the comedy. Then we got a call from the White House saying that they wanted to, I don't know if they wanted to see Elliot maybe, or I don't know, but he took me along or they asked me to, I don't know which. I went over to the White House and sat down with Al Haig, Len Garment, Charles Ellen Wright, Fred Bizart, and maybe one or two others. And they really insisted that we not indict. And said, they made the argument, the legal argument, which I didn't believe, but they made the legal argument. And they also, it was clear that there was a political motive because Agnew's base was the same as Nixon's base. And they were afraid if we attacked Agnew, it would hurt Nixon with his base, and Nixon was in trouble on impeachment grounds. So he didn't want to squander the base. Now, some people have written about how it was a plot by Nixon to get rid of Agnew. It was not a plot by Nixon to get rid of Agnew. They were dying not to have us attack Agnew. But we wouldn't give way. And Haig said, let's go see the president, which is supposed to be, when they drop that on you, you're supposed to quiver. Well, on the way down the hall, Elliot said to them, we have to go to the men's room, which is not true in particular, but we go in the men's room and turn on all the faucets to defeat any listening devices. You have no idea the atmosphere in the White House in those days. You had no idea whether something was turned on listening to you or not. So we turned on all the faucets and whispered to each other. And Elliot said, I think it's a resignation issue, don't you, Bob? I said, it certainly is. So we turned off the faucets, went to see the president. Now, the resignation issue is a hard one to deal with because you can't walk in and say to a president, you do this or I'll resign. Because if he's any kind of a president, he'll do it and make you resign. You can't be blackmailed that way. On the other hand, you can't let him go so far to commit himself that it's too embarrassing for him to back out once you bring up the resignation issue. So it requires delicate handling. You have to sort of, by the seriousness with which you take it, sort of indicate to him that there's something here that may be resignation issue, and don't press us too far. But you don't say that. It's a very serious issue and something we would have trouble explaining in our professional capacity, et cetera, et cetera, et cetera. Now, as it turned out, I made the argument, if you're sitting where Nixon did, he had his feet up on the desk for a large part of this time. Elliot was here, I was here, Bizart was there, and Haig was over there. And the debate took place between Bizart and me. And I mainly had a legal debate about the seriousness and how we could ever explain it, and how we just couldn't do it. Without saying you can't do it, we said we couldn't do it. I made the argument too that politically it was better for the administration that if they let Agnew hang out there going through all the name being played up every day in the papers because other people were indicted and being tried and were implicated in Agnew. The long, dragged-out nature of that would be much worse for the administration than going after Agnew. Nixon was wonderful. He kept saying, what do you say, Bob? What do you say, Fred? And he back and forth, and he would ask intelligent questions. Elliot told me later, as we left, he said, you just saw Nixon at his very best, and at his very best, he is very good. And after a while, Nixon said, well, I guess you have to indict him. And I thought Bizart and Haig were going to fall off their chairs because they'd been sent out to prevent us from indicting him. I think they took it very well. We then went. Nixon said, "I just wish we had a top-rate attorney to handle this case because it's going to require some delicacy." And the Solicitor General is the government's main attorney. And I was not relishing this thought because you might think that I would be eager to get a case like that. But I was new and, frankly, somewhat frightened of a case like that. But I didn't say anything about it. I went back to the office, and Elliot called up and said, "You're going to argue it." The president just called me. That was all right. But we sat down and we wrote a brief. I had two assistants, Keith Jones and Ed Kitch. And we worked morning to night, but, I guess 16, 17 hours a day, because we only had a week. We had another brief. We had two briefs. Agnew had also filed a motion to shut down the grand jury on the grounds that it was leaking. And the case was in the district court in Norfolk. But Saturday night, we filed the brief, both briefs. And then, as I mentioned in the book, I had just Sunday to prepare my first argument ever in the Supreme Court. I didn't even know what the case was about Sunday morning. But I went up there with my erudition being very thin. And I think we had Agnew. His basic argument was that the president couldn't be indicted, and therefore neither could the vice president. I think it's true that the president can't be. He can be impeached, but until he's impeached. But that argument doesn't apply to Agnew. As you look at the function of the vice president compared to the function of the president. In any event, I think Agnew's attorneys thought it was a lost cause. That's what Elliot thought anyway, and they began the plea bargain. And he got out of it that way.
Do you recall Haig talking to you about his fear of a double impeachment in this period?
You mean Nixon and?
Yes.
Double impeachment?
That was the Haig recalls the great concern.
Well, it could be we were concerned, and Elliot was concerned, particularly, and he was right, of an impeachment and a criminal trial running side by side. Impeachment of the president and a criminal trial of Agnew. That's not a double impeachment, but it's the same idea.
It was interesting in your brief on Agnew, you talked about co-conspirators and the difficulty that you had these people who were indictable, that were linked with someone whose indictability was in question, and the implications for those others, the contractors or the state officials, I'm not sure who, of this particular person not being indicted. And I was wondering if at the time you were also thinking about the Watergate grand jury, which had faced the same challenge because Richard Nixon was, or could have been viewed as part of a conspiracy,
Well, it wouldn't apply. That was a reason for indicting Agnew. And if you took the same reasoning over, you'd say it's a reason to indict Nixon. But it doesn't transfer that way, I don't think. Because the arguments in the brief about why a president can't be indicted, I think, are perfectly valid. I think the impeachment's the only route.
Well, you make the argument in the brief, and it's not fair since I've read it more recently than you have. Or you wrote
I should say I did not prepare in any way for this meeting because I figure I don't want to get ideas that are not my own.
But what's interesting, you talk about the president as being a very special constitutional creature, if you will, whereas the vice president is not.
No.
In fact, the vice president was an afterthought.
Is what?
Almost an afterthought at the end of the Constitutional Convention. But I know it's been a long time, but when I was reading this, since I've had some occasion to think about the debates that arose in the Watergate Special Prosecution Force offices over whether you could indict the president or not, and they ultimately chose the unindicted co-conspirator route. I found it interesting to see the arguments you made about the need to indict Agnew because otherwise you would not be able to obtain justice with regard to the co-conspirators in the case.
Yes, but in addition to that, indicting Agnew didn't cost you anything in terms of government efficiency. I mean, if you indict the president, all hell breaks loose in the executive branch. Indict the vice president, nothing happens. He's not a very important figure. Yeah, there's something to the question about what kind of cost you're going to pay for what benefit. And if you don't indict Nixon and indict his other people, I don't think they get off. Did we say that?
Well, it doesn't. You didn't really. I didn't read a brief on Nixon. I read the one on Agnew.
I know, but that's the one. That's a brief about Nixon.
Yes. Well, you set the president aside and established a special constitutional box for him, if you will. And describe why he can't be indicted. And then you say the vice president, it doesn't apply to him because he's in the same category as all other federal officials.
Yeah.
He's like a judge.
Yeah.
You really create a box around the president. That's my sense of the argument.
I wrote the brief against Otto Kerner. You remember the Illinois?
The judge?
Yeah, the one who went to prison for tax evasion.
I'm not familiar with the.
He was a judge. He wrote the Kerner report about.
You mean about
two nations?
The riots? Was that in L.A.?
What?
Oh yes, go ahead.
It was about race relations in general. He was governor, then he became judge on the Seventh Circuit Court of Appeals, and when he came up for indictment, he raised the point that he couldn't be indicted before he was impeached and so forth. And the U.S. attorney out there, Bill Thompson, recognized that I had a similar case. And he called up and said if I could write the brief against Kerner as sort of a warm-up for the brief against Agnew, and I did. The brief against Agnew was much better.
Speaking of Kerner, that makes me think of a few other issues that arose at the time. Do you remember the issue over whether to reopen the investigation of Kent State? It sort of was ripening at the time.
I don't recall it. That would probably be down in the depths of the criminal division, and it wouldn't come to my attention unless there was an appeal.
Now, help us. I'm not a lawyer, and many of those who watch
this. No need to brag. No need to brag.
Thanks. What role? And I guess it gets back to Haig's request of you, but even before we get to the Saturday Night Massacre, if the special prosecutor subpoenas the president for materials, does the Solicitor General doesn't get involved in defending the president, does he?
No. The difficult that came up because later on they wanted me to argue the case against Jaworski for the president. And the trouble is, the special prosecutor is part of the Department of Justice, and it would hardly be appropriate for the head of the Department of Justice to be opposing his own guy. So, no, what was your precise question again?
I was just trying to understand why it was that the Solicitor General in the summer of '73 was not the one who was writing the brief for the president against Archibald Cox, and you just explained it.
Yeah, well, you mean on the tapes?
On the tapes issue.
Oh yeah, no, that was a